How many does that leave? Because
That's what I'm trying to
doing
figure out.
good with math this
4.
late in the day. 4, so 4 in the afternoon then. So our hope is to get through all your witnesses
I can say this
tomorrow.
for the record. One witness I intend to call tomorrow is not going to be 35 minutes.
Fair enough. Do you plan to call that person in the morning or the afternoon?
I'm leaning towards the afternoon. That could change depending on the flow of the morning, I would guess. If the morning goes pretty...
Can you tell me which list they were on when you gave it to the state? Was it Thursday afternoon, Friday morning, or Friday afternoon?
I didn't put them on days, but I believe they were in the maybe the second flow of names. If
You just
that
want to tell
helps,
me who it is so we can prepare so that person is told to come in the afternoon rather than wait through the morning?
I don't want to say who it is.
But
They were here today, if that helps.
Yeah, I know who it is. It's Erica Patterson, Your Honor. There's no
Maybe.
mystery here.
Maybe
all right,
it is,
that's
maybe
what I
it isn't.
would have.
Thank you. We'll have everyone else here at
That's
8:30.
interesting because what if that was not who I was referring to?
Then you need to tell me right now so I can make an alteration to that.
Come on, Judge.
Sir,
So
I
can we
need
at
to
least
keep
be
this
fair?
moving
Can we at
along.
least be fair and say that's not due to me though?
That would not be fair to say.
How?
It's
How? The state said that they needed 5 to 7 business days to present their case. Did they or did they not say that on the record?
and there's.
So how
It doesn't
did
matter how we got there at this point. I'm trying
Then they
my
need to chop,
darndest
chop.
to get all the
Should've been
witnesses
chop, chop.
done. I'm directing the state to have Miss Patterson come tomorrow afternoon.
If that's
And the
what I was
other
referring to,
witnesses?
which I wasn't, but everybody think they know what I'm thinking.
Then you need to tell them if it's someone else, and if you want her here in the morning.
I'll
then
say
that-
this. Everybody that was here today that didn't get called, I have them here tomorrow. So that'd be 1, 2, 3, 4, 5 people.
Do you want to be responsible for calling each person tonight and telling them what time they need to be here, or should we let the
See,
state
here we
do
go
that?
with this again. There's something that's impossible to do.
That's not true. You have
How's it
access
not
to
true?
a phone.
So somebody's gonna answer a collect call from someone they don't even know. Nobody in this courtroom will answer a collect call and pay for a phone call from
not
somebody
my
that you
understanding
not know.
of how it works at the jail. That you can.
Yes.
There's other means to make phone.
These witnesses don't just show up by the tooth fairy. We have to communicate with them. They have jobs. They have families. I've explained this 3 times to Mr. Brooks. If he wants our assistance,
Objection. She can chill with all
he
that. She can
needs
chill with all that
to-
tone.
hold on,
Because
hold
we
on.
can
I know
get
we-
on that if that's what it is.
Hey, I
We
know
can
it's been a
definitely
long
get on
day.
that.
Let's keep this civil.
That's what I'm trying to do, but
So
she gonna have to tone it down.
I think both of the parties are getting a little
For real.
frustrated. I'm getting frustrated. So, Kohler,
who they be thinking
Guth,
like.
Hayes, Patterson.
Let lawful law.
You will be removed to the other courtroom as I complete
So I'm being
the
held in
instructions.
contempt again. Is it civil or criminal?
All right. One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break. That you may not raise the issue of jury nullification in any way.
Your Honor, hold up. Hold up now.
And to tell you very
Your Honor,
expressly
I
that that is the
vehemently-
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record. But
May
my
I ask
rule
for legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
All of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot
Well,
answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your
to
Honor,
a court of
because-
appeals, not this court.
No, this is, I'm supposed to be in this admiralty court because you haven't, if we're under Article 3, then we should be in common law court. That hasn't even been addressed, if we're in a common law court or an admiralty court.
That's a baseless argument, sir. I don't even need
And
to
what law
address
and
it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you an opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also,
please let me, sir, you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't.
on
Your
the
Honor,
issue
that's a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to
circumstances
be
of
fair.
this case and your insistence on arguing jury nullification has resulted
I
in this
haven't-
court creating this rule.
I haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware. That is my ruling.
I object to that ruling, Your Honor. I object to that ruling.
Do you want to be present at that?
For the record, I'm not a person. I'm a human being. And no, I do not consent to or agree to being present at a jury view.
Because the more
You can't
general
change the law, Your
principle-
Honor. You can't change the law. That's
I'm not
practicing law from
changing
the
the law,
bench.
sir, but the general principle.
I know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do that.
practicing law from the bench.
You are if you're changing. Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
The
And what
state-
happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make
be
a
found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me repeatedly today.
I'm informed.
All right, thank you. So with that, you have a right to be present at that jury view. Did you hear me say that?
I'm informed.
And I would like you to be there. I believe it is a piece of evidence. That's why I've drafted jury instruction 152 the way that I did. Did you hear me say that?
I'm informed.
So my question to you then this morning is, do you want to be present at the jury view of the vehicle?
I don't see the reason why I would need to be present.
Saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent, in
Your Honor,
addition to, no, let me finish.
and
Arguments.
you made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
That's the third time.
Okay, now you can say
So, Mr. Brooks, I'm advising you yet again, the time
I don't
has now
consent to
come.
being called
That's
that name,
another
Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You
And-
were brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be informed of the truth. It's not me trying to give.
Are you telling me, sir, that you are going to let me ask you a question.
Hold on. I'm not trying to give.
That you are going to disregard my very clear directive to you to not bring up the topic of jury nullification.
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, I direct your attention.
You just said that. Did you not just say that, Your Honor?
Sir,
you said I couldn't instruct them.
The jury has the power, but not the right to nullify.
Right. You said the power. You said the power.
Listen to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you
telling
are
you
going
no such
to
thing.
disregard
I just told you what you just said.
my direct...
That interrogation?
Objection.
Oh.
I'm referring to what he just said at the beginning of the answer.
I'm going to sustain the objection. Next question.
Grounds for the sustain?
Next question.
Grounds for the sustain, Your Honor?
Next question.
So I can't get no grounds. Okay.
$16.
So it'd be fair to say that you didn't read the Miranda rights till somewhere after already interrogating the detainee for 15 minutes at least.
Objection.
Grounds.
Misstatement.
You read you read the Miranda rights after 15 minutes.
Yes, thereabouts.
Do you recall why you didn't start the second interrogation with the Miranda rights?
I'm not required to read them immediately.
We got open the door on how old she told me she was.
Interrupted.
We can ask that question.
He is over the top animated right now. Mr. Brooks, I'm ordering you to sit down and to let the state finish.
No, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And once he brings that letter, then he can show it is inadmissible. He will not be questioned. And under 90611, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
As it relates to the jury instructions?
I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah,
it?
I got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image of sir. Now it's all this sir and all this. I'm gonna get where I'm going. Try to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
That's not double jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with?
To the jury instructions. I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you. Do you have any requests as it relates to the jury instructions?
I just told, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you're saying.
Then you should put the
What about
headphones
that
on.
don't you understand? What about that don't you understand? Did you see headphones? You can see everything. You can see boxes, but did you see headphones?
Have you asked for headphones to be provided, sir?
I shouldn't have to ask for them. I asked for my boxes to be moved.
I believe they took them away previously because you were so agitated. They were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop. You sit up here and do everything you're doing and think God don't see what you're doing? You ought to be ashamed of yourself. And yeah, I got requests. It ain't like they gonna be honored though.
As it relates to the jury instructions, sir, what are your...
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Legal mumble jumble. He's reading from some typewritten transcript. I can see that from where I'm sitting. I don't know who's giving him these materials, but he has an agenda here. It's to stall, delay, disrupt, intimidate, and it's not going to work. Thank you.
Objection to that. Your Honor, that's a load of crap. I just want to object to the disrespectful comments that was just made. I'm not trying to hold you up from what you're gonna say, but that's a load of crap.
76. The 76 count. Just want to make... It says near Frame Park, so it is in there. But that was just one question I had. All right.
325, 141, 172 at the end because it was...
I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling.
If they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles. That
There was no shock device on
It
your
was a
ankle,
shock
sir.
device. I was told it was a shock device.
Mr. Brooks,
And
that's
it was
why I'm
covered
making
up.
the record.
It was covered up by black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks. I think the public should know that. The jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your
I
characterization
respect your
of
ruling,
those
but
as,
it should be noted.
Your
It should
objection
be
is noted
noted.
for the record.
It
Your-
should be noted that I had a shock device on my ankles. That's fact.
It
It's
is
a
not
fact.
fact, sir.
It is a fact. I'm the one that had them on my ankles. I inquired about what they were. Obviously, I'm going to require about what's being put on my body. I was told that they were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee. So I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public. Purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed? The
All right,
public
Mr.
doesn't
Brooks,
deserve.
you're-
The public deserves
You've
to
made
know.
a record,
The
and
public
it's
deserves
noted.
to know about
And-
things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this
It's
voltage.
absolutely false that you
That
have a
is
shock
not
device
false,
on,
and
sir.
you know that it's not false.
Well, I have the photographs
Well, show
that
the
will be
where's
part
the
of the
photographs?
record,
Where's the photographs?
and they
You
will
just
be
said they would be sealed. Why do they need to
from
be
public
sealed?
view
Why
for
do
the
they need to
reasons
be
that I've
sealed from
already
the public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the public?
I need to move on to scheduling.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
Good morning, everyone. I will get started. I will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good morning, Judge Sue Upper, Leslie Basie, and Zach Witchow appearing for the state of Wisconsin.
Good morning. Good morning, sir. Please state your name for the record.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any other facts in the charging instruments.
Record should reflect that the individual known to this court as Darrell Brooks is present in person in custody in street clothing, wearing a suit and tie and a mask.
For the record, I
today.
did not consent to being called that name, Your Honor.
All right,
And we still have yet to address subject matter jurisdiction.
the court
for
has
the
addressed
record.
it for the record. That I issued in this case last week. A second
what written
copy was
decision are you
provided. Please
referring
don't
to?
interrupt me. A second copy was provided to you. I know you saw it because you tore it up yesterday. So I'm not going to address it any further.
Are you
are
talking about
mistaken and wrong. Mr. Brooks, do you have any requests?
I'm tired of my rights being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up here and make decisions based on what you think I said when I didn't give consent for you to do any such thing?
From what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly, sir.
whatever.
So you're doing it once again.
Whatever. Just make your record. By what's the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you seek to have
Do you want
contact?
to open up the door to the other act's evidence of
That's
you
not
using-
opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have,
It's
but you
unfairly
can
prejudicial.
open the door
Your
to
Honor,
that,
It's
sir.
unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness
Then
can
have
get on
you
the
turned
stand
that
and lie on the
document
stand.
over to the state?
Come on, man. Y'all know that's not right.
It,
Y'all know that's not right.
then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When
So-
did you receive the
so that-
document?
so what-
Hold on. When did you?
When-
I'm having you make an offer. But when did you receive the
Okay,
document?
but that I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
That's
then,
not true. That's a
No,
misstatement of the
that is
evidence.
true.
No.
She said it herself.
No, marking an exhibit is not creating an
No,
exhibit.
not marking the exhibit. She said
We're not
that
going to go
essentially-
down a tangent, sir.
All right,
I'm going
I'm
to
not gonna
focus
argue
on
with
this,
you,
and I'm
but
going to
it's
give
not
you the
fair.
opportunity
It's not
to make a
fair.
record.
It's not
All right?
fair. It's not fair. Your Honor.
When did you receive this document that you claim was sent by this witness?
It's not claim. It's for a fact.
Sir, it hasn't been established yet. I need to make a
So
record.
do y'all want
I
the
want
letter?
to see
Y'all
the
want the
letter.
envelope? What?
I want to see the letter.
Okay, so I gotta.
And I wanna
so now
know
I gotta
when you
bring that in.
received it.
Now I gotta bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures, and I
Okay,
want
well,
you to
that
make
was the
a
proper
record.
procedure.
If you don't make a record,
So
then
what?
I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
are
it.
you aren't
Stop
even
it.
letting
You're a
me
public
ask the
servant, Your Honor.
questions.
I respect your courtroom. I
You
respect
do.
you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to in
man.
count 77. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying book. I'm looking at the Bible. Thank you. It's not just a book. It's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by it though? Anyway.
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm not doing it tomorrow.
Then you'll forfeit your right to give one, sir, because as we have...
You can't force me not. What type of court is this where you can say you're gonna force somebody not to be able to give a closing argument? How's that lawful
Sir,
law?
if you choose
How
not
is
to
that
give
lawful
one...
law? How's that lawful law?
Sir, if you choose not to
Damn,
give
good,
one,
right.
you're not letting me finish, and you're mocking me right now, which is incredibly disrespectful once again.
Okay,
You didn't
say
even
that
let
how
me
you
get my
want to.
sentence
You
out.
always want to make a incorrect record. Go ahead. Make your incorrect record. Go ahead.
To what the state brings up regarding the redacted recording, I would remind Mr. Brooks the court did enter some rulings previously. Why do you have to roll your eyes at me? Let's start the morning off on a good
I
note,
didn't roll
sir.
my eyes at you, so I don't think it's fair that you should say I rolled
I
my
saw
eyes
you
at
roll your eyes at me. I'm not
I
going to
didn't roll
debate
my
about
eyes
it.
at you, so don't do that.
Well, Mr. Brooks, I'd appreciate a little bit more respect. These
I would too,
rulings,
Your Honor.
let me finish, because now you're interrupting me. These rulings were entered by the court.
Very much like to get through the defense witnesses tomorrow, Your Honor.
I don't know if that's gonna happen.
Well, that's the order that I'm making in terms of the times people need to show up.